Hello, everyone, and welcome to Miami. My name's Eitan Goldman. I'm a partner at Zuckerman Spader. I'm one of the co-chairs of the White Collar Institute, along with Ray Benoon and my partner, Maggie O'Donnell. And on behalf of Ray, Maggie, and myself, I want to welcome everybody to the 40th edition of the ABA White Collar Crime Institute. We have a great program. For the first time in history, we have a Justice of the United States Supreme Court who's going to be speaking to us. Tomorrow morning, the Honorable Ketanji Brown Jackson is going to be speaking in this room. Yeah, wait, that's the good news. That's the good news. The bad news is that the Justice's security detail is going to be setting up a magnometer outside this room and has asked that everybody get here early, like real early, like 7:30 early. And that may feel particularly brutal tomorrow to those of you with a hangover. Given the packed social schedule that I know so many of you have tonight, I do want to give a shout out to the firms and companies that are putting on even more extravagant and outlandish receptions and parties this year. I also want to thank our planning committee. This was a particularly challenging year to plan the Institute. One of the great things about the Institute is that it brings together people from the White Collar Defense Bar and the government, and you get to hear from the prosecutors, and that's important to have that participation, particularly from the Department of Justice. As some of you who aren't in Washington may not know, but there's a new presidential administration in Washington. And every time there's a new administration, it's hard to plan this because this is in early March and the people usually haven't gotten confirmed to their permanent position yet. This year was particularly challenging, given the transition was unlike anything we've ever seen before, and the tumult in the Department of Justice was unprecedented. So one of the effects of that, and this is by far, less serious than some other impacts, we are not going to have people from the Department of Justice with us this year. It's unfortunate, and hopefully they'll be back next year. I know that many people in this room have watched the changes at Justice and some of the other changes in Washington with real concern and even fear. And there's talk about threats to the rule of law, talk about threats even to American democracy and the republic itself. And it's not my place to offer my personal opinion here about how realistic those fears are. But I know this to be true. It is more important than ever that we have conferences like this. There is a quote attributed to Churchill that democracy is the worst form of government except for all the others. I don't know how literally accurate that is, but the point remains. And I've done a lot of reading recently, no reason, about how democracies deteriorate and fall and the rise of some of those less attractive forms of government. One thing that seems to be a consensus is that authoritarianism, totalitarianism, tyranny in general cannot coexist with a vibrant civil society. Never gave much thought to the civil society and whether I participate in or support American civil society. But then I realized this is civil society. This conference is an example of civil society. I always thought of this conference as basically a reunion, great parties and some interesting speakers and panels. It's more important than that. This is an example of American civil society. And whatever your opinions about the current administration are, I think we all agree that the U.S. is an increasingly polarized country, and it's important to have places, venues like this conference, where we can have conversations, where we can even have debates, respectful, civil debates. Because in the end, we're all Americans, except for those few of you who aren't. We're all lawyers, except for those few of you who aren't. And we're all colleagues. and there is more that unites us than divides us. I know that is a cliche. That doesn't mean that it's not true. So I want to thank you for your participation. I want to thank you for supporting American civil society.
Okay, good afternoon. My name is Sidney Butcher. I'm the chair of the Criminal Justice Section for the 2024-25 bar year. And I share a lot of the thoughts that Eitan just talked about in terms of expressing appreciation for all of you folks that are attending this conference today. I'm a state trial judge in Maryland. And not only do I want to thank you for being here, I appreciate our sponsors. And I echo that I really do appreciate Eitan, Maggie, and Ray that led our planning committee with all the hard work. I'd also like to recognize the staff, a wonderful staff that put everything together for purposes of today. Everything looks really good. I know that we're going to have a couple of good days of solid panels as well as some fun in the evening that Eitan was talking about. So if Maggie could also come out, please, if you could come up here. The criminal justice section, we refer to ourselves as a unified voice of criminal justice issues for criminal justice professionals. One part of that is white-collar crime and our committees that focus on those areas. There's a couple of things that I want to highlight, and they're not at your table, but when you signed in, you should have seen forms that look like this where you can scan to try to join to be a member. So when you signed up for the conference, you either elected to become a member, or if you're a member and you're not involved, we're asking for you to get involved. There's a lot of work, a lot of opportunity for us to put on some exciting panels and talk about some issues that are pressing within our community. In addition to asking for you guys to be active members of our association, one of the other things I'd like to highlight is some of the different opportunities that we have coming up. You should have seen a number of advertisements for some of the different conferences that we're having across the globe. We have a forensics conference that's going to be taking place in May. We have our Healthcare Fraud Institute that's also going to be taking place on May 1st. Our Southeast White Collar Crime Institute that will be taking place in September. And we typically have every year a London Institute and our Global Institute that takes place every 2 years. This year it's going to be different. On November 17th, 18th, we will be in Geneva, and it will be a combination of our London Institute as well as our Global Institute. And our first vice chair, Nina Marino, if you could come out, please, has been assisting with leading that charge. And as many of you who don't know, Nina will be the chair of our section in about 2 years. I asked for a couple of minutes because, as Eitan said, it was very difficult for the planning committee to try to put on this conference this year. And we know if anyone's been involved with bar associations or trying to put on panels and things of that nature, there's always some type of work that goes into it. There's different issues that you have to kind of think about, and some that you weren't even aware of that pop up from time to time. At the beginning of this year, when I took over as chair, one of the things that our section council wanted to do is we wanted to highlight the individuals that started the conferences for the criminal justice section. So we did that with our Southeastern White Collar Crime Institute, we did that with our London Institute, and we're going to do it again today by recognizing someone that's been dealing with this for 40 years, Ray. Ray, if you could come up, please. Many of you have known Ray for a long time. I've gotten the opportunity to have some conversations with him over this past year, and he's clearly someone that's very passionate. And I can only imagine what it would be like for someone that had started this 40 years ago. He told me at length multiple times on how when he first started this conference, there were only a couple people. And now it's ballooning into this situation where it's the must-attend event of the year for white-collar crime professionals. So the criminal justice section passed a resolution that reads as, the ABA criminal justice section expresses its deepest appreciation and gratitude to Ray for his outstanding service, leadership, and dedication to the section and the broader legal community for the founding of the National White Collar Crime Institute. Further resolved that a copy of this resolution be presented to Ray as a token of our esteem and in recognition of his invaluable contribution. Please join me in celebrating Ray Banu.
Well, the plans was for me to talk tomorrow, so I'm going to be very short. Thank you very much, Sydney and Nina and the whole criminal justice section. I mean, I really don't deserve this because this is a work of a lot of people, and it just so happens that I can facilitate things and sometimes make it move. But Eitan and Maggie have been tremendous help. The whole law firm of Zuckerman Spader, Sherry Mead, who took over this past year the organizational work that used to be done by the CLE group, and she's transformed. All you have to do is look. If you've been here before, look at the changes. It's more pleasant to be here, the way the whole conference is organized, but she does that year-round. And so it's really, I mean, a pleasure to be able to work with a group of professionals. Sherry had with her Jamie Campbell and others. So really, this is the whole planning committee that we start working on this in May. So it's really a lot of people who are working on this, and it's really all of them who deserve really the recognition. And more importantly, it's all of you, because you come and year after year, and you make this program what it is. I mean, it's fantastic because not only do we have all of you participating, but we have also all the events. And the whole purpose of this institute was initially to have an annual meeting, reunion of the White Collar Bar. So that to me is really what's really important and nice about getting together every year with people we haven't seen in a few months. Thanks. Thank you all.
The final note that I want to make, I said at the beginning that we really want people to get involved and become active members. You have an opportunity. A lot of time people are like, well, what does that look like? We have our International White Collar Crime Committee that's meeting tomorrow if you want to stick your head in from noon to 12:30 in the Hibiscus Room. And we also have our White Collar Crime Committee that's meeting from 12:30 to 1 in the same room, the Hibiscus Room. Thank you.
So we're the next panel, the Enforcers panel, slightly modified, but we do have enforcers are starting in a moment. While we're waiting, actually, one of the things I wanted to really mention is that next week we have to be in San Diego next year. Because we had to make up for a year that we skipped during the pandemic. But after that, the hope and the plans are, with Nina Marino's help, who has been really working with the Miami Beach Convention Center, is to permanently have this conference in Miami Beach. And hopefully, so starting 2027, that's where we'll be. So we're holding our fingers crossed, but we think we're going to manage to accomplish it. And now the suspense. There should be a... There they are. Come on.
So who chose the Talking Heads for their walk-on song? We have a very distinguished panel here. Not the panel that we thought we were going to have, but nevertheless a terrific panel. Rich Donahue and Marshall Miller bravely, at the last minute, agreed to jump into the void that was left when the Department of Justice withdrew from the conference. So very grateful to them, because otherwise you'd just be listening to the three of us the whole time. We have next to me Antonia Apps, who is the acting deputy director of the SEC Division of Enforcement and the director of the New York Regional Office. Earlier in her career, she was an AUSA in the Southern District of New York and a partner at Milbank. And she is, among other things, a fellow of the American College of Trial Lawyers. Brian Young, sitting next to her, is the director of the CFTC Division of Enforcement. He had been acting director since January and recently was made permanent director, so congratulations. Brian had been the CFTC's chief whistleblower officer, and before that spent almost 20 years in the Department of Justice, starting as an honors grad and eventually running the fraud sections litigation unit and then the antitrust division's litigation unit. Rich Donahue, acting deputy attorney general in the first Trump administration, as well as the principal acting deputy attorney general, the PADAG. Before that, he was the U.S. attorney for the Eastern District of New York, and earlier in his career, he was an AUSA in the Eastern District of New York. He spent 7 years in active duty status in the Army JAG Corps, so thank you for your service, and is now co-leader of Pillsbury's Investigations and White Collar Practice Group. Marshall Miller, at the end, until late last year, was the PADAG. He has been in and out of government service throughout his career, serving as a AUSA in the Eastern District of New York, chief of the criminal division of that office, in the criminal division front office in the Obama administration, and recently returned to Hecker Fink as a partner. So let's start with the government officials that we have. Antonia, can you just walk us through what you see as the SEC's enforcement priorities going forward, to the extent that you can? I know it's early.
Yeah, thanks. First, my remarks today reflect my own views and not necessarily those of the Commission, its staff, or the commissioners. And before I address your question, I just want to say, start by saying the staff in the Division of Enforcement are talented, career public servants who take very seriously their role in fulfilling the mission of the Commission. This agency is 90 years old and has been through a multitude of administration transitions. And I guess the only constant is change. And I wanted just to make a note of how proud I am of the work of the staff of the division for pushing forward with their cases and their matters despite all sorts of challenging circumstances, and I'm privileged to call them my colleagues. Thank you. Now to the substance of your question, Eitan. I want to assure everybody that the Enforcement Division's program is moving forward. The current acting chairman, Mark Ueda, who, for those of you who don't know, actually worked for many years with the nominee to take over the permanent position of chair, Paul Atkins. Mark has, the acting chairman has stated publicly that he believes that the Enforcement Division has always played and will continue to play a vital role in ensuring that the Commission advances its three-part mission: protecting investors, maintaining fair, orderly, efficient markets, and facilitating capital formation. So you can expect to see some some changes around based on priorities and different policies that the agency may pursue, that some of which we'll talk about in more detail today. But we're going to move forward with the core enforcement agenda that we have always moved forward with, whether it's offering frauds, Ponzi schemes, disclosure cases, accounting fraud, insider trading, other practices that are deceptive practices on the market, whether it's price manipulation, issues relating to investment advisors, breach of fiduciary duties, broker-dealers, regulation best interest, all of the standard fare that enforcement moves forward with, you can expect to see that we will continue to move forward in those program areas under the new administration. Just to highlight a couple of cases that have been brought in the last 6 weeks, we brought charges against a broker who was also an investment advisor, and he converted approximately 180 brokerage accounts held mostly by elderly clients into advisory accounts, and didn't adequately disclose that by changing them from brokerage accounts, where it was a fee-based, a commission-based fee, into the advisory accounts, that they would be paying significantly higher fee structures, and of course the individual would receive higher compensation. And that failure to disclose was charged as a breach of fiduciary duty under Investment Advisor Act 2062. We've brought charges against a CEO of a company, an AI chat technology startup company, that falsely represented to investors it had generated tens of millions of dollars in revenue, when in fact it only generated approximately $500,000, resorting to the creating fake email accounts playbook and sending false information to investors and the board about its successful strategy. We've brought insider trading cases, other offering fraud cases. We continue to work in parallel with our law enforcement partners, both the criminal authorities at the federal level and at the state level. One of the recent offering fraud cases that we brought was in fact in parallel with the Manhattan DA's office. So these are just a flavor of the things that we continue to work on at the division. We still get tips and whistleblower referrals in all of the programmatic areas that we've been working on over the last several years, or decades even, some of them, and I expect to see that work go forward into this administration.
Thanks. Brian, Acting Chair Pham has announced that the Enforcement Division of the CFTC is going to be going back to basics. Can you tell us a little bit about what you see that meaning?
Yes, of course. And like Antonia, I'm here speaking only for myself and not on behalf of the commissioners or any of the staff in the CFTC. I really appreciate her comments about her staff, and I feel that I too have the good fortune of working with some really fantastic people in the CFTC's Division of Enforcement. They do great work. They're really good people, and I think the taxpayers should be indebted to what they do for us every day. Acting Chair Pham has made public statements that the CFTC is getting back to basics, and I'll try to tell you what that means in practicality. And the first thing that means to me is that we want to focus on cases and matters that have a good chance of returning money to a victim of a fraud or a manipulation scheme. So we want to take people and make them whole to the extent that they lose money through some sort of misconduct. Another core of our enforcement program is the traditional mission of anti-market manipulation. So we are going to look at market manipulation cases. That's going to be a big focus in our core markets, such as foreign exchange, metals, ag, those types of things. So the fraud and manipulation mission is going to be a major focus for our program now, I think, as it traditionally has been. From a process standpoint, one thing we would like to achieve is to continue to incentivize cooperation. We want to have more cooperation between the Division of Enforcement and our registrants and people we interact with. And to that end, you may have seen on February 25th, we issued an enforcement advisory on cooperation, remediation, and self-reporting. And it's important to remember that any enforcement advisory doesn't bind the commission. It's just the policy of the Division of Enforcement. But it does give you, I hope, some sense of what we're looking for in cooperation. And one way we thought we could incentivize cooperation, or at least put practitioners in a position to advise the client, is to give a little bit more certainty on the mitigation credit that we'll provide under similar circumstances. So to that end, we create a mitigation matrix. And on one axis, you have the types of self-reporting. On another axis, you have the types of categories of cooperation. You can go through that matrix and be assigned a percentage. And that, when we apply those factors, is the presumptive percentage that you would get for your cooperation. On the self-report, we have a 3-tier scale. There's no self-report, satisfactory self-report, and exemplary self-report. And we assess cooperation on a 4-tier scale. No cooperation, satisfactory cooperation, excellent cooperation, and exemplary cooperation. What's important is that we think of remediation analytically as part of cooperation for the purposes of this exercise, assigning remediation credit. And the way it would work procedurally is we'll take a look at a case if we think we want to resolve. We'll think about what the CMP's civil monetary penalties would be. From the civil monetary penalties, we then undertake our self-reporting and remediation analysis. So I guess it's a little like criminal practice where you have the base offense level and then you go to the 5K committee and subtract from there. There's one part of the policy I want to talk about that's sort of unique to the CFTC agency, and that is traditionally the Division of Enforcement has required a report to the Division of Enforcement for there to be self-reporting credit. The policy changes that and allows, under the appropriate circumstances, for cooperation credit, self-report credit, when somebody reports to one of the operating divisions, such as Division of Market Oversight or Market Participants Division. To us, I just think that's a more practical way to approach it because a lot of companies are trying to resolve their problems with the operating divisions. And if they do that and they bring that information forward in good faith, we think that they should be, we think that they should count for their cooperation credit. The only thing I would ask of practitioners is just when you're interacting with the operating divisions and you're trying to resolve a problem in good faith, just go on that basis. But we don't want to have any forum shopping or anything like that. And so if it's appropriate to bring something to MPD, then please do it by all means. And if that gets brought to MPD, for example, we would assign cooperation credit. Relatedly, CFTC registrants do chief compliance officer reports. And if a chief compliance officer report timely identifies a problem or a self-disclosure, then that can count as your self-disclosure in and of itself on the 4 corners of the document. Again, it has to be timely. You don't want to sit on something if you filed your CCO last week and you're going to wait another 11 months to do your next one, that could be a little bit of an issue. But the CCO is an opportunity in a format that you could use to make a disclosure that counts for mitigation credit.
Thanks, Brian. Just to clarify, the MPD is the Market Participants Division, not
That's
the
right.
Metropolitan Police Department?
That's correct.
Okay.
DOE
the
is
regulatory divisions.
DOE is Division of Enforcement, not Department of Energy. Sometimes.
Right. Okay. Let's talk about crypto. It has occupied a growing segment of both the criminal and civil regulatory docket in recent years. And I think you can divide crypto enforcement actions into different buckets. There's the failure to register that both the CFTC and SEC have brought. And then there's the fraud, which seems relatively ubiquitous in crypto world, that the department has brought criminally and that both of the agencies have brought civilly. I think that we already know, sometimes it's hard to know what's going to change at this point in the new administration. I think we already have seen changes in crypto. President Trump has pledged to be more friendly to crypto, to turn the United States into the crypto capital of the world. Old crypto task force, I know there was a DOJ crypto task force, there was a CFTC crypto task force, and there was a SEC crypto task force, and they've all been merged or abolished or changed. And I want to start with Antonia because I don't think anywhere has seen a more dramatic change than the SEC, where under Chair Gensler, the commission asserted its jurisdiction over a whole range of digital assets. and brought a lot of cases involving not just fraud and manipulation, but also failure to register. Many of those cases at the time resolved with the companies agreeing to move offshore and geo-block Americans. In the 6 weeks that we've had the new administration, we've already seen the SEC dismiss pending cases against Coinbase and Consensus and halt investigations into executives at Gemini, OpenSea, and Uniswap. I know, again, Antonia, it's still early, and that there's a crypto working group now established out of the White House, and it's just starting their work. But what do you see as the SEC's future enforcement efforts with respect to crypto and other digital assets?
Yeah, so you're absolutely right. This is certainly an area where there has been a policy shift at the Commission. On January 21, the acting chairman, Mark Ueda, announced the formation of a crypto task force at the SEC, which was to be and is headed by Commissioner Hester Peirce, who has tremendous expertise in the area. And the task force is dedicated to developing a comprehensive regulatory framework for crypto assets generally. It has drawn from staff across the agency to consider those topics, and I think Commissioner Peirce has certainly been speaking about the potential direction that the task force is going in, and in particular focusing on soliciting public viewpoints and public opinions on and giving input to the path forward. You also referred to a separate task force in crypto, not to be confused. Task force is not the right word. The White House itself issued an executive order creating a working group for digital assets, and the SEC is part of that working group. But I just want to point out that is a White House coordinated group, and what I was talking about before under Commissioner Peirce is an SEC task force. Shortly after Acting Chairman Ueda announced the formation of the SEC Crypto Task Force, the SEC withdrew or rescinded, I should say, Staff Accounting Bulletin 121. That was a controversial bulletin at the time, I should say, which provided interpretive guidance for an entity's obligations to custody crypto assets and requiring the entity to recognize the crypto asset as a liability on its balance sheet. That was rescinded under SAB 122. And since then, the acting chairman also announced the formation of a new unit or group within the Division of Enforcement. So the new unit is called Cyber and Emerging Technologies Unit. That was announced last month. And that has new leadership, Laura Delade, who is going to complement the work of the task force. And if you look at the press release announcing the formation of that unit, there were a number of items covered in that unit's agenda, from fraud committed using emerging technologies such as artificial intelligence and machine learning, use of social media, hacking, cyber, and importantly, in answer to your question, I guess, the press release announced that that particular unit would continue to look at fraud involving blockchain technology and crypto assets. So all of that's a long way of saying what I really want to underscore is, notwithstanding you've seen, and currently one case has been dismissed that was a pure registration case, the Division of Enforcement is moving forward with investigations and litigations in the crypto asset space where we see fraud and where we think we have jurisdiction under a Howey analysis. So we are not, well, that's basically
Not
the
vanishing
positions.
from
We're
the
not-
crypto enforcement scene.
I was looking for words along those lines, but yes.
Okay. But we shouldn't expect any more standalone registration cases. Is that fair?
I don't want to get into that level of detail on this panel, unfortunately. I think a lot of this is going to be wait and see how this plays out. But I just wanted to make the point that we're not walking away.
Got it. Rich, I think crypto is probably less of a big deal when you were acting DAG in Trump 1.0. But how do you foresee the department reacting and acting in an era where, you know, the president wants us to be the crypto capital of the world?
Yeah, well, we're certainly in a transition period with regard to crypto, most of all in the SEC realm. But I do think once this is settled somewhat and we actually get a real regulatory mechanism and scheme in place, that there's going to be a lot more crypto work than there has been, just because the industry is going to be more settled, more established. It will have all the tests and requirements and obligations that other industries have. We are playing catch up, to be sure. Certainly Europe's far ahead of us in terms of regulatory thoughts, but as Antonio pointed out, there are numerous task forces working on this at this point. Hopefully something will move through the Congress. We'll get clear regulatory guidelines, which, you know, Coinbase and others have made the point for some time that they've been asking for it. You can have discussions about that one way or the other. But once those regulatory mechanisms are in place, I think there's going to be a lot more work for us as counsel, in-house and outside counsel, to help those companies operate within the regulations. So I don't think it's going away by any means. We've got the first crypto-friendly administration, I guess, but that means that there's a lot of work to be done and a lot of work that's going to be needed even once these mechanisms are put in place.
Marshall, any words about the kind of intersection between crypto and national security?
Thanks, and I'll do two quick preliminaries. One, this is probably the easiest of my ever appearing on this panel to say what I say is not represent the views of the Department of Justice. So that's one, and the second thing—
Mine do, though. Mine represent the department.
I do also want to take a moment, echoing what we've heard before about the staffs at the SEC and CFTC, to say that DOJ also is filled with career professionals, AUSAs, trial attorneys, special agents, paralegals, sports staff, who are also dedicated, talented, public-spirited, and patriotic professionals, and I want to recognize those folks as well. Going back to your question, Eitan, I do think, as you said in the outset, DOJ's work in the crypto space, I think, will largely continue with focuses on many of the things that Antonia mentioned: fraud, theft, cybercrime involving cryptocurrency, and the like, money laundering involving cryptocurrency. I think that activity will continue, and through things like the National Cryptocurrency Enforcement Team at DOJ and the Virtual Asset Unit at FBI, a core of professionals there, prosecutors and agents, are true subject matter experts in this space, and I think you'll see them continue to bring those investigations and then bring prosecutions where some of that crime that I mentioned before is located.
The CFTC and the SEC have these long-standing whistleblower programs where, you know, hundreds of millions or even billions of dollars have been, you know, paid out to incentivize tips, complaints, and referrals. The Department of Justice, I mean, aside from the False Claims Act context, has recently rolled out a pilot program. I think it actually may have been last year at the Institute where Attorney General Garland announced that. And there was a bunch of press and a bunch of different offices started their pilot programs, and then kind of haven't heard anything about it. Marshall, do you know, is that still happening? Is there anything public?
I can speak up to where it was at the end of the last calendar year. There are really two parts to the whistleblower program that was set up. The first being a whistleblower awards program modeled on the programs at the SEC and CFTC, with a slightly different funding mechanism through forfeitures. But that's an awards program, so folks who bring new information to the department relating to areas, particularly where the SEC and CFTC whistleblower programs aren't applicable, those tips can qualify for whistleblower awards. There, I think it was announced back in December that there were over 250 different tips that had already come in just during the first few months of the program, and many of which were under investigation at the time. But those kinds of whistleblower tips take time to investigate and then determine whether there's, they're there and whether there are cases that can be brought. Brian is an expert, of course, in these kinds of whistleblower investigations and can speak to the fact that it does take time for them to materialize into actual cases and awards. The other part of the program was a whistleblower non-prosecution program. So the first was for people essentially not involved or not significantly involved in the activity itself, the criminal activity that they're reporting on. The other is for people who are involved, and there the program, which was piloted at a few U.S. attorneys' offices, related to essentially voluntary self-disclosures by individuals to obtain non-prosecution agreements rather than monetary awards. Certainly anecdotal information reported by a number of different U.S. attorneys that they were seeing interesting reports, but I don't think there's been anything that's been public about particular cases.
Thanks. As Marshall mentioned, Brian, you are expert as the former chief whistleblower officer in the CFTC. Can you tell us any changes that you made while you were chief whistleblower officer, or anything that's going to be different, or is it mainly continuity we're going to see from the CFTC in terms of whistleblowing?
We tried to have our whistleblower adjudications move more quickly. There were some internal process points that we put in place to do that. And I know that we had more adjudications, whistleblower application adjudications last calendar year than we've ever had before. That's important for the program. And I was thinking about what this audience might want to know about whistleblowers and the whistleblower program, and I can tell you two things that I want to share with you. Let me back up for 1 second and tell you for a second about the program. It's a cash for reward program, and in the history of the whistleblower program at the CFTC, we've paid out $390 million in whistleblower awards, 42 million of which was paid out last year. About 40% of Division of Enforcement matters involve a whistleblower, either as somebody who brought the case to us or somebody who assisted in an ongoing case. That's significant for an agency like ours that can have, in some instances, access to market data to do surveillance. The fact that the whistleblower program occupies such a big part of our docket is very, very significant in my view. Let me tell you two things that surprised me when I became the whistleblower director that I didn't really think of before. And the first is how many whistleblowers or how few whistleblowers come in directly to the CFTC as opposed to raising their problems internally with the company first. I don't have empirical data to tell you on that, but anecdotally, it was rare that I saw a whistleblower tip for an insider, for somebody who just went straight into the CFTC and did not try to raise it internally first. I read a study by a Harvard Business School professor named Jonas Hess, and he studied 1,335 False Claims Act cases. And what he found was 53% of the relators, the whistleblowers in those False Claims Act cases, reported internally first. So the lesson that I draw from that is one way to resolve these claims or cases is to listen to the whistleblowers, or a lot of this could be resolved short of litigation if the company would engage with those folks before they feel they need to come to the regulator. And indeed, the CFTC's whistleblower program is authorized to make award payments to compliance officers who report internally first and then wait 120 days without satisfaction, and we have done so. And so what I want to let you know is that if you don't listen to your compliance officers, it could be somewhat of a problem for your clients. The second observation that I had is that I saw many cases in which a whistleblower came in and started engaging with the Division of Enforcement far sooner than the company did. And if you're on the defense side representing a company, that leaves you in a dynamic where somebody else is shaping the case or shaping the narrative or offering their views to the enforcers, which maybe you would dispute. And I got the sense that a lot of companies would have been better served to disclose earlier, especially if there was a whistleblower out there, which they may or may not know about, to give us their views and their ideas. Now, of course, we can look at a whistleblower's complaint, and we do a lot, and say, well, this isn't any good, we're going to decline that. But you should be aware that there are sophisticated whistleblower counsel out there that know their way around the Commodity Exchange Act. And if you decide not to disclose or self-disclose a problem at your registrant, they may be talking to us anyway, and you're missing an opportunity. The final thing I'll say on that is, and I didn't really appreciate this until I started really working on whistleblower cases. A lot of whistleblowers are temperamentally sort of suspicious people, and sometimes I'll see situations where they may have pool counsel, but a person at the company, right, they have pool counsel, but they're also calling their own whistleblower lawyer directly, and perhaps not involving the pool counsel. And so I just want to tell you that, because when you're thinking of whether you want to make a disclosure, I hope that our new policies will make that more attractive or at least more predictable to you. But you should also be aware that we may already know by virtue of a whistleblower telling us that.
Thanks, Brian. That also raises some obvious ethical issues, right? If you're pool counsel and you're representing individuals in an investigation of a company, and they also have the potential to be whistleblowers and get monetary awards, you know, what are you supposed to do as pool counsel in those situations? I mean, send them to a different lawyer?
I can't hold myself out as an ethicist on this, but I'll tell you this: the client may have would have a financial incentive to report a violation and get a whistleblower award. So that's something that your client may have. They may have that financial incentive, and that's something that you're just going to have to think about and deal with. I am aware of cases where pool counsel, maybe they don't know the whistleblower program, maybe they just don't want to be involved in that part of the case, have spun off a client to separate whistleblower counsel for that separate advice, right? And then sometimes the whistleblower isn't interested in pool counsel's opinion and they're just going to do it on their own. But I have seen pool counsel engage a whistleblower lawyer to advise the client on that particular aspect of the representation.
Yeah. And I mean, under the SEC program too, there's a lot of very complex rules about who can be eligible for a whistleblower award if they don't satisfy certain criteria, and how they submit the award, or their tip, if you like, their whistleblowing tip, to the SEC. So that can be very fraught. It's a highly specialized area, and so I just point that out. I think it's a similar model to the CFTC program.
And there's also a well-developed SEC whistleblower bar out there representing.
There is a well-developed whistleblower bar, some of whom were formerly the head of the whistleblower office at the SEC. The SEC's program has been in place since 2010, so it is a well-developed program, and you know, we get thousands and thousands of tips every year. We have a team of people who triage those tips, and it's a very well-developed program.
Just out of curiosity, what percentage of TCRs actually end up resulting in investigations, and what percentage are just kind of nut jobs?
We don't use
legal
that
term.
term.
Temperamental challenge.
Yeah. So that data is actually not public, so I can't share that with you. But
You telling me what it rhymes with?
unfortunately, no. Although I do want to underscore also, you may come back to this, Aidan, the cooperation points that Brian was making, I think, are important for our agency too, particularly in this administration.
Yeah.
So I'm happy to chat about that.
Okay.
You didn't take me up on that, but I'm teasing.
The next topic is something that I know is weighing on a lot of people in this room, and that is the FCPA, which has been this amazing growth engine for the white-collar criminal practice over the last several decades. There was an executive order signed recently announcing a 180-day pause in investigations and brought cases because FCPA enforcement has been, and this is a quote, overexpansive and unpredictable, and has hurt the competitiveness of U.S. companies. During Trump 1.0, there was some thought that the FCPA would not be prosecuted, or at least not as vigorously, because Donald Trump, before he was elected president the first time, had criticized the law. But FCPA prosecutions pretty much continued apace. There wasn't much of a drop-off. Rich, this feels different, is it?
Well, I don't think it's the end of the FCPA. I don't think it's the end of FCPA enforcement. We are certainly in a pause and a transition. I think what emerges from this will be a different type of FCPA enforcement, but it's going to continue. It's become part of the fabric not only of our profession and practice, but of international business. And we've all been writing and reading and speaking about why this is not the time to have companies go out and either draw down their compliance programs or start bribing officials in far-flung countries. There are a lot of good reasons, whether they be statute of limitations, other regulators, enforcers around the world, lots of AUSAs out there and others who can bring FCPA cases under the guise of something that's not called the FCPA. Most FCPAs, in my experience, are wire frauds. So the fact that that particular statute might not be available doesn't mean there's not a tremendous risk for the businesses. Interestingly, the FCPA unit was not dissolved, right? And it's a little bizarre that we have to sit around and say, well, that's the fact that this unit wasn't dissolved is a promising signal. But, both task force was dissolved. You mentioned some others earlier. A number of them have been dissolved. Foreign influence task force has been dissolved, and so on. FCPA was not. And if you look on, I think it's page 4 of one of A.G. Bondi's day one memos, it's actually the one dealing with cartels and TCOs, transnational criminal organizations. Perhaps somewhat oddly, there's an FCPA section in there. And it talks about FCPA and reprioritizing it. And this was all prior to the president's executive order from 10 days or so ago. And what you see there is not only does the unit survive, they are directed to focus on or prioritize cases that involve TCOs and cartels. And you might say, well, how applicable is FCPA to TCOs and cartels? Limited, but it's real. There are some circumstances where it's real. So they'll prioritize that. But within that memo, it says that for the TCO and cartel cases, the U.S. Attorney's offices now have power to proceed without the FCPA unit. Now, we've had a lot of discussions over the years about the FCPA unit. Whenever I say that AUSA should have FCPA authority, alum of the unit look at horror at me, but the reality is AUSAs have power to do RICO, they have power to do all kinds of things. I don't know why the FCPA is different. And I think it's a good step that they've given that authority to the U.S. Attorney's offices, albeit in this limited way. I think what's going to emerge from this 180-day pause is a much broader authorization for the U.S. Attorney's Office to work those cases. What does that mean 18 months down the road? It means instead of having 20 or 30 or 35 trial counsel in the FCPA unit in Washington, you now are going to have thousands of AUSAs around the country who are authorized to do FCPA or FCPA-like work. And so we may actually see an expansion in the investigations and prosecution. So a lot of moving parts, something different from what we're used to will emerge. No doubt, to the extent that it intersects with national security interests, you're going to see it used. It's another tool in the tool chest. And to the extent that it involves, for instance, China, you're going to see the FCPA used. Last year, most FCPA, if you take the top 10 or so countries that were involved, I think China obviously leads the list and has more than twice as many FCPA-related matters than the next, which I think was Brazil. So you're going to see the use of it, perhaps in certain areas of the world, in ways that are a little bit different from what we've seen in the past, but I don't think FCPA is done.
Just to chime in on that, I think another element of the equation here is the Foreign Extortion Prevention Act. So that was passed towards the end of, in the last year or two, bipartisan piece of legislation. And the idea of that legislation was to focus not on the supply side of the bribery equation, but on the demand side, the foreign officials who are demanding bribes from U.S. companies and other U.S. issuers and the like. There's been no reference to pausing FIPA investigations or prosecutions, FIPA being the acronym for the Foreign Extortion Prevention Act. And that makes sense, right? Because if the theory is the U.S. business has been undermined in terms of its ability to compete because of the FCPA, that's not at play when you go after the foreign official who's trying to extort the bribe. As I said, it's also a bipartisan piece of legislation out of Congress. So I think that's another way that you can get at the same transaction, right? If you don't go after the U.S. company that paid a bribe, but you do go after the foreign official that demanded the bribe, that's a potential avenue that doesn't run afoul, I think, of the presidential memo, but still achieves the goal of trying to level the playing field for American companies.
I would say too, and I think that's an excellent insight, FIPA hasn't really been tested yet, right? It's 13, 14 months in, whatever it is at this point. But it is entirely in line with this larger reprioritization and reorganization of the department and other parts of the government. But I do think this pause has created an interesting opportunity. If you have a company now that you know is under investigation or that is considering whether to self-disclose, you really need to look at hard at this window that you have, because you have a real opportunity to go in and get a declination that 2 years ago you wouldn't get, and maybe 2 years from now you wouldn't get. This is the time to go in and say, look, we have a handful of people in some region or a country manager, whatever the case may be, because I do think the department is going to be much more amenable to declinations, to favorable resolutions now, while they're still trying to figure out what their position is on FCPA.
Rich, you talked about kind of a theme here. Do you see connective tissue between a lot of the things that the administration has done in the first 6 weeks in terms of getting rid of kleptocracy and the FCPA pause? And
Yeah, oh yeah, definitely. I mean, it looks a little haphazard from the outside, but there is a theme, and there is certainly a perspective that's being applied here. So if you take sort of the America First philosophy, whatever that is, all the perspectives and the priorities that go with that, and you take that and you overlay it onto the Justice Manual, overlay it onto the org chart for the department, you see a lot of what we see right now. So what you're seeing is crimes that impact Americans, crimes where Americans are victims, whether that be narcotics, violent crime, whatever it is being prioritized. Crimes where people think that the victims primarily are not Americans, such as kleptocracy cases, are being deprioritized. And that's why you're seeing things like the Klepto Capture Task Force being disbanded, but other things like Project Vulcan, Project Alpha being elevated to the AG's office and the DAG's office as well. So there is a philosophy at work here. Part of that philosophy is they don't trust the bureaucracy. And they particularly don't trust DC bureaucracy. And so what you're seeing is a movement of resources, and this happens periodically, right? We've seen this pendulum swing. We've seen the pendulum swing between Main Justice and U.S. Attorney's offices. They are all one team. We all understand that. But for all of us who served in both venues, we understand that there is some creative tension. The reality is a lot of AUSAs want to do things that people in Washington will not let them do. And to some extent, vice versa. A lot of U.S. attorneys say, I don't want those people coming into my district and trying a case or bringing an indictment or whatever it may be. All those things get worked out because everyone's a professional and they're highly, highly competent people. That said, what you are seeing now is this distrust of the bureaucracy, this view that the bureaucracy is self-interested and bloated and needs to be fixed. And in executing on that perspective, they look at it and say, well, look, U.S. Attorney's offices have been around since 1789, right? The department's been around for over 150 years. These things were being done before there was a Klepto Capture Task Force, before there was a corporate unit in NSD. Let the U.S. Attorney's offices do them. Let them be coordinated through Maine. Let Maine provide expertise, consultation, in some cases approval, that's fine. But I think you're going to see that pendulum swing so that you're going to have more resources in the field, but also more authority in the field. And again, that gets back to where we're going to be in 2 years. You're going to have a lot of AUSAs who have a lot of authority that they don't have now and have less of a administrative burden of getting this or that approved at Main Justice. I'm not saying that's right, wrong, or anything in between, but that's part of the pendulum swing here. And it'll be interesting to see what emerges from it, but I don't think we're going to be out of work anytime soon.
That's reassuring. Speaking of pendulum swinging, monitorships seem to be very cyclical, right? In Obama, monitorships were in. Trump 1.0, they were out. Biden, they were in. Can we expect monitorships to be out again?
Yeah, I think that's one area where there was just, on different sides of the political aisle, substantive disagreements, different views, whatever it may be. I do think that having been in the department in every administration from, I guess, Clinton to Biden, you do see that kind of come in and out of vogue. And there is a philosophy. We would sit around in Marshall's old office, my old office, and the conference room and talk about what's appropriate for this or that company that's now in this situation. And in Republican administrations, you tended to hear the term babysitter, right? Do they need a babysitter? Or are we just going to hold them responsible? Are we going to take the individuals who did this, hold them fully responsible, whether that's by criminal prosecution or otherwise, look to see if the company has fixed things to what our regulators here talked about earlier, which is what you really care about, whether they fix it to make sure it doesn't repeat. Look at their history, which is, of course, relevant. And I just think there's much more of a tendency in a Democratic administration to say, yes, we should have a monitor in there, should we have this third party in there, whereas the Republican administration, much less likely to say, bring this third party in, say, if they screw it up again, well, then we'll take care of it by prosecuting even higher on the chain. But, we are unique in our respondeat superior approach, right? And so most places in the world, the country manager commits an offense, the country manager is responsible for it. And you're not talking about whether a corporation has to take a guilty plea. And I think there's some sympathy to that issue and that view in the current administration and other Republican administrations.
The Justice Manual, just one sec, the Justice Manual takes great pains to say we should not treat business entities any different than we treat individuals for cooperation or for whatever else. Right. Never been obvious to me why we should treat them differently. Yeah. Do you see wholesale changes to that approach where we're not really, even with respondeat superior and the ability to hold a multinational company criminally responsible for the acts of one employee, will we not be doing that?
Yeah, I think government is going to look at this differently. I think the department's going to look at it differently, and I think this creates a very important opportunity to go in and argue that our company, our shareholders, our employees should not be held responsible for what 6 guys in a region did, and certainly not criminally. I think you're going to get a much more receptive audience now than you might in other times. But look, it's entirely relevant. We've had these discussions back and forth for many years now. What about the company that comes in over and over and right? You can't tell me it was this 6 guys, prosecute them, we fired them, now it's this 6 guys, now it's this 6 guys. You have a problem. You have a compliance problem, you have a culture problem, you have a leadership problem. And should they be held responsible for that? Yes. The question is exactly in what form or fashion.
Although recidivism is different for companies than individuals
of course,
too, right? I mean, you can have misconduct on one continent and one sub, and then misconduct does not necessarily mean the company is, bad to the core.
Right, absolutely.
Marshall?
Yeah, I mean, I do want to chime in here because I think Rich has done a good job of identifying a bunch of places where the pendulum is swinging. I do think there's an important area where I think you're likely to see as much continuity as change, and that's in the national security space. To be sure, the administration will shift its focus to its priorities, and you've seen that in a lot of the memos and executive orders. And the particular focus, I think, at the top of the list is the cartels and transnational criminal organizations that Rich identified. And I think you see a regional element to the way they're going to enforce and investigate at the intersection between national security and corporate crime or misconduct. I think you're going to see a lot of focus on Latin America, Mexico, Colombia, Central America, the places where those cartels and the particular transnational criminal organizations that were declared foreign terrorist organizations in the last couple of weeks are located. So I think you're going to see a lot more activity there, and as I think evidenced by the disbanding of Task Force Klepto Capture and some other actions, you're going to see a lot less focus regionally on Russia. but I think you're going to see a maintained focus, if not even increased focus, on China and Iran. So you're going to see some shifting regionally, but I don't think you're likely to see the kind of pendulum shift that Rich mentioned in other spaces in the national security investigative realm. Rich, I think, rightly pointed out the way that the administration has, in connection with these TCOs and cartels, given more authority out to the field, to the U.S. attorneys' offices. I thought it was really interesting also that there was discussion by the administration about searching for amendments or having their Office of Legislative Affairs go to Congress and get amendments to expand the extraterritorial reach and amend and make it easier to bring extraterritorial cases. That doesn't sound like a Justice Department that is just going to close up shop in this space. That sounds like a Justice Department that wants as much flexibility and ability to investigate internationally as they can get. So I thought that was pretty interesting. And I think the foreign terrorist organization designation is also going to mean that any organization or company that operates internationally in the Latin American region, for sure, and probably also in Asia or the Middle East, is also going to have to be very focused on the material support laws and not running afoul of material support for a foreign terrorist organization, as well as IEPA and some of the other national security statutes. By the way, they all carry quite long statute of limitations as well. We're talking 8 or 10 years, depending on which statute, rather than the usual 5. So I do think there's a lot to be concerned about and to be focused on from a compliance perspective, from a client advisory perspective, about international business operations and how to be sure that companies don't end up like the Lafarge company, the big French concrete company, which ultimately was the first company in many, many years to be charged with material support for terrorism, in that case, with respect to bribe payments to ISIS. Another example of bribe payments where the primary charge was not the FCPA. So again, another example of what Rich talked about different tools in the toolbox.
Got it. But Rich also talked about opportunities that his clients have. I assume that you're not telling your clients this is a great opportunity to go out and bribe a bunch of foreign officials. That's not on your menu.
Probably not a great idea.
Antonia, can we talk about changes to the SEC's, the way the commission treats cooperation, and also the Wells process and meetings?
Yeah, so let me start with cooperation. I don't want to be the only one that doesn't mention the importance of self-reporting, self-policing, cooperation and remediation. Obviously, there has always been that program at the SEC, at least since 2001, Seaboard Factors, the Seaboard Report. And you saw over the last 18 months, frankly, a lot of messaging in the commission cases about the value of that kind of cooperation and self-reporting. There were a number of cases that were issued that had no penalties attached, precisely because of the significance of the self-reporting and cooperation that the company provided to the SEC, and even reduced penalties and no penalties, even where you didn't self-report, because we obviously have a robust whistleblower program, but nonetheless came in and met those other conditions. And I think going forward, we're going to continue that, but I think we're going to lean into that even more. Unfortunately, the SEC doesn't have a declination program, if you like, or option that the Justice Department has, where it will issue these declinations. Although we do have a tool called 21A, we issue reports. We've done it in the past. We may try and do more of that in the future. But I think what you will see if you come to the SEC, you self-report, you cooperate, remediate, I think you will see more frequently than in the past administration that we just don't bring charges at all. I want to emphasize, now we don't have any way of publicizing that, and absent a declination, but I really want to underscore the importance of cooperation for your clients. And we've talked in the past about what cooperation means, and I want to also point out the value of remediation. Remediation where if it's the 6 guys somewhere or whatever the hypothetical is, if you take care of the problem, if you reform the procedures, if you fix the compliance problem, we're suddenly less likely now than we were ever before in not imposing an independent compliance consultant on you, but we're also much more likely today, if you really truly have remediated the problem, to not bring any charges at all. This commission in particular feels very strongly that companies should be rewarded for doing the right thing after they've discovered a problem. And for those of you who have clients at whom you're involved in the examination side of the program, I do want to just also point out that if there's an exam team that comes on and identifies deficiencies or issues in your compliance, your client's compliance programs, and the registered entity or the public company fully, well, sorry, I misspoke, exams don't go into public companies, but the registered entity fully remediates at the exam stage process, there's, again, we're going to look very hard as to whether or not the division enforcement should even start an investigation if the registrant has fully remediated all of the deficiencies that the examination program identified and restored any money to any victims that were, or investors that were out of pocket owing to the compliance failures. Obviously, it's not a one-size-fits-all. There may be cases where the facts and circumstances are too egregious for that, but I think this commission is very much open to resolving matters in an efficient way than necessarily getting another case over the line. And I guess the other process, do you want me to?
We'll talk about
Yeah, do you want to? Yeah, okay, great. So just, and actually Chair Atkins, well, not yet chair, but Paul Atkins wrote an article when he was, I think he might have been commissioner at the time in 2008, emphasizing the importance for prospective defendants to have greater access to process generally, and that covers both Wells meetings and also the sort of access that you might get to the SEC's files in advance of any sort of final determination by the commission. So the last administration, I think, signaled that there would be fewer Wells meetings for folks who asked for it. In this, I think that there is a change in this administration with respect to that. If prospective defendants are asking for Wells meetings, you're likely to get one with either both the director, the deputy director, or one of us, and which I think is a little bit of a change from the last administration, although I think in truth for very big complex issues, Wells meetings were still continued. So that's one change. And I also think we are messaging that we want to make sure that folks have access, that potential defendants have access to the information they need to make the Wells process meaningful. So, I think the practice varies around the division. When I was in the New York office, I always strongly encouraged staff when they had Wells meetings or were explaining to defendants the nature of the charges against, that they thought were appropriate in a particular case, that they would do a fairly extensive evidence review for a reverse proffer, if you like, for the company or for the individual, so that people know what the evidence is against them, so we can have a meaningful dialogue. And that is delivered in various forms across the agency, but I think we are looking to make sure that there's more consistency in that space and that defendants do have access to what they need to be able to meaningfully engage. We want to know we have the evidence right. We want to know we have the facts right. We want to know that we're doing the right thing in bringing the case. So anything that can facilitate that dialogue is a good thing.
I've been coming to this conference for 20 years, and I don't think there's ever been a government speaker that doesn't encourage self-reporting and cooperation. And
which is why I didn't want to be the first. Yeah.
I said it when I was enforcement director of the CFTC. You all should call us before we call you. And I get why it makes sense from the government perspective. I think a lot of people are still, one of the reasons is, non-process are never publicized, right? And I think that the agencies and the department have made good faith efforts to try to be more transparent about what credit you're actually getting if you self-report and you cooperate. And Brian, that the grid that you kind of compared to the sentencing guidelines, where you can go down and say, this is, we're going to get 30 to 40% off, or we could get 55% off if we both self-report and have exemplary cooperation. I mean, that's great, except for the question becomes 55% of what, right? And earlier you said, well, we're going to decide on what the appropriate CMP is going to be, and then we're going to go down from there. But I think there's a good deal of skepticism, not about the CFTC in particular, but just in general, that the number is kind of reached, and then you back into the cooperation credit, and that really kind of past settlements are more of a benchmark than any kind of percentage departure that you get from cooperation or self-reporting.
Well, the CFTC doesn't have a sentencing guidelines the way that criminal practice does. And so I recognize that determining the CMP in the first instance isn't as regimented as it would be under 2B1.1 or something like that. But all I can tell you is the way I would approach a case when I have to look at papers to review it. And my first question is going to be, let's start with where the CMPs should be or where they would be without any cooperation credit. So tell me that number first. And if you can, give me some examples of how we've treated somebody similarly situated in another matter and try to start with that premise and then work to evaluate the cooperation and remediation and apply credits from there. But having said that, there is no sentencing guidelines for the CFTC. And even in the sentencing guidelines, I mean, in criminal practice, a defense lawyer can always call you up and say, hey, how are we going to get this person into Zone C? Like, how are we going to do this? And so even under the sentencing guidelines, I've seen that sort of negotiation technique unfold. But I do hope that, and I think that the enforcement advisory we issued on February 25th is going to arm you to tell your clients this is how they are going to look at cooperation, and this is sort of what you're buying if you go in and cooperate. So maybe there's more work to be done on the front end, but all I can tell you is how I would approach the problem, which is to sit down with the staff and say, let's start with point one. How much do you think the CMP should be without remediation or self-reporting? And then the second step of the analysis is, what is the mitigation applying the factors that we have in this policy?
Eitan, can I just add one quick thing on your point about non-process not being publicized? I think that's generally true, particularly true, of course, if at the Department of Justice, if the department determines that there really wasn't criminal activity. That would be bizarre then to publicize the non-criminal activity of an investigated entity or the like. On the other hand, if there is a declination, even though criminal activity was identified because of a voluntary self-disclosure, that declination letter is publicized and is put up on the fraud section's website where the fraud section did it. And I think U.S. attorneys' offices are heading down that path as well. So I do want people to know that where there is a declination based on a voluntary self-disclosure, there is a set of declination letters out there that you can look at that discuss why the Department of Justice decided to decline.
Fair point. I wanted to leave a couple minutes for any questions from the audience. I think we have a microphone available, right? Yes, we do? Okay, great. It's over
While
there.
we're doing that, just real quick to follow up on the point Marshall made earlier about national security. Clearly, that's where the intersection is greatest. And we've got all kinds of sanctions, export issues, obviously, front and center these days. You now have tariffs, right? So we're going to have companies perhaps trying to avoid tariffs and things like that. So supply chain, China and beyond become absolutely critical for any international company these days.
And non-payment of tariffs actually can violate the False Claims Act,
Yeah, exactly right.
Yeah.
Yeah. So you're going to have, back to our whistleblowers, right? And I don't think whistleblowers will be out of favor over the next couple of years. I think you're going to have real opportunities for whistleblowers to step forward and say, my company is trying to avoid tariffs by X.
Right. We have a microphone in the middle of the audience. Anybody have any questions for the panel?
Yeah, hi, Gaspar Ledem with Global Investigations Review. I'm just wondering, in light of Trump's order to pause FCPA enforcement, I know that mostly applies to, or it seems like it mostly applies to DOJ. What does that mean for the SEC? How will the agency continue to enforce FCPA or not?
I think it's a little early to tell. We're obviously going to follow the lead of the DOJ, so it's just too early to tell.
All right.
Any other questions?
Trying to be as spry as I can to get to the mic. Hi, Jordan DeGroat, Reed Smith, New York City. My question is how we see the intersection of national security priorities and vehicles for enforcement that we traditionally think of, whether it's in the crypto space or it's in the SEC. I mean, these cartels and transnational criminal organizations, they do finance their money through traditional finance vehicles, and they use crypto quite a bit. So are we going to see a reprioritization of those enforcement agencies and personnel towards kind of the same type of work, but just dealing with different entities? And how do we think we're going to see crypto enforcement change in the perspective of how the cartels might be using cryptocurrencies, or how they might be using offshore financial vehicles for their practices?
I think you're going to see a lot of that, obviously. This expertise that's been developed is not going to go to waste. I think once we have a real regulatory system in place, yes, we're all going to work very hard to keep our clients within the regulatory system, but regardless, there are going to be all these entities that are operating outside of it, because crypto is not your traditional finance, and it is amenable to abuse, whether that be Ponzi schemes or money laundering or whatever it is. So you're going to see, by necessity, whatever the philosophy is, whatever the view is of crypto, you're going to see by necessity FBI, DOJ more broadly having to focus on crypto, and regulators as well, of course, because it's there, it's big, it's amenable to abuse, and it's going to be misused. So that will lead to investigations and prosecutions, and the world will turn.
Yeah, I mean, I agree with that, and would just add to that, we've also seen, as attributed by various government agencies, foreign adverse actors, whether they be cyber criminals or nation states, stealing crypto and to finance activities that are dangerous to our national security. So I think, again, you're going to see that as part of the mix, in addition to what Rich said in terms of the
And that'll be a big part of the regulatory requirements, right? I hope, anyway. You can't have North Korea stealing crypto and supporting their regime that way. And that is what's happening. We all know that. We've seen it publicly reported. That's a major national security concern for the United States, again, regardless of your political leanings or perspectives. Things like that will have to be addressed, and hopefully the expertise across regulators, enforcers, and others will be put to good use to do that over the next few years.
I think we have time for one more question, if anybody wants.
My name is Ed Shohat. I'm a partner with Jones Walker here in Miami. What I'm about to say is not the opinion of my law firm, but is the opinion of me and many of my friends. I attended 2 sessions this morning, and I've listened carefully to this session today, and I'm mortified. It seems to me as everybody here is acting as if we are in a business as usual situation. I hear you talk about the pendulum swinging, and that it's common to have the pendulum swinging, but I've seen in the last few weeks the destruction of the independence of the DOJ. I've seen prosecutors fired merely because of who they investigated. I've seen orders entered by the new director of the FBI to move and fire agents because of who they investigated. I've seen the FCPA denuded. I've seen FARA denuded, and everybody's acting as well. Everything is going to continue as usual. I haven't seen one word, not one word, out of the ABA about what's happened at the Justice Department. The ABA did put out a statement about DOJ, which was lukewarm, but in the proper tone. I'm wondering why it is all of you can sit up there. The SEC dismissed the most significant cryptocurrency case in its history, all because of politics. Let's not hide from that. Why are we acting as if business is as usual? Thank you.
I'm not going to have any of the panelists address that. I think that that those sentiments are probably widely shared, but it's not really the forum. I mean, if you have issues with what the ABA as an institution is expressing itself on, there are opportunities for you to try to make the ABA be noisier about this. But I don't think anyone on this stage or any of the speakers in this conference believes that what's going on now is normal or business as usual. I want to thank the panelists here. About 48 hours ago, I didn't know if we would have a panel. So I want to thank Marshall and Rich for jumping into the void. And I want to thank Antonia and Brian for showing up, which takes courage. And I think we should show them our appreciation for their presence.